Hello, good afternoon, everybody. I hope you can hear me. I'm going to request the host of the Zoom to mute all the attendees so that it's easier for us to follow each other and to also prevent any other additional noise that we might hear from the attendees. Good afternoon, everyone. At least afternoon for those in Uganda. My name is Jeffrey Kaddu. I am the moderator for this afternoon's very important webinar discussion. And we are joined by two very prolific speakers in this discussion, who I am going to be introducing shortly. However, before I do that, I would like to welcome all of you and introduce you to the Chartered Institute of Arbitrators, Uganda. We launched a chapter, and the Ugandan chapter of the Chartered Institute of Arbitrators is the organizer of today's webinar. So today's webinar discussion is going to be focused around the effect of the Africa Continental Free Trade Area on arbitration, and I'm going to be the moderator. I'm going to be joined by two panelists that I'm going to introduce shortly, Derek Chizito and Professor Crispus Nyombi. The topic for today's discussion is going to focus around dispute resolution, specifically arbitration, within the context of the Africa Continental Free Trade Area Agreement that is now in its 7th year. The discussion is also going to delve into other modes of dispute resolution that exist under this agreement. We will assess their suitability against the goals and objectives of the Free Trade Area Agreement, and whether the dispute resolution system that is in place is suitable or is valid for the disputes that are likely to arise out of the trading or during trading of this agreement. So without any further ado, allow me to introduce today's panelists. That I am going to start with Professor Crispus Nyombi. Professor Crispus Nyombi is a professor of international commercial law at the University of Derby in the United Kingdom. Professor Nyombi is a member of the World Bank International Center for the Settlement of Investment Disputes panel of arbitrators and the Permanent Court of Arbitration in The Hague. He is Uganda's representative at ICSID, the International Center for Settlement of Investment Disputes, and was a member of Uganda's delegation that negotiated the Africa Continental Free Trade Area Agreement and its investment protocol. Professor Nyombi was also involved in negotiation of the revised COMESA Investment Agreement 2025. He is a member of an international experts committee that drafted the award-winning Africa Arbitration Academy Model Bilateral Investment Treaty for African states in 2022. I apologize, I'm in Uganda. So yes, that's some of the bric-a-brac of third world countries, but I'm sure it will be back shortly. So Professor Crispus is also a representative. He also represented IGAD in the United Nations Commission on International Trade Law. That is the Working Group 3 negotiations that happened in 2019. He led high-level discussions on the greening of the Africa Continental Free Trade Area at the United Nations Economic Commission for Africa in 2022. He's a generalist in international commercial law and an academic with specialist interest in international investment law. He has published over 60 books, journal papers in leading journals, and he has led 15 projects funded by the United Kingdom Research Councils and the British Academy. Professor Crispus Nyombi is also a visiting lecturer and has had visiting professorships at Makerere University in Uganda, the University of Juba. He has also taught at several universities, including the University of Bedfordshire. Professor Nyombi is the founder and the director of the Center for Justice, Law and Society at the University of Derby, and has supervised over 18 PhD students and examined over 13 PhDs worldwide. His research and impact have been Forster rated by the UK Research Excellence Framework since 2021, and he has been invited to address distinguished audiences and deliver keynote addresses in over 40 countries around the world concerning all aspects of international investment law. These include in the Paris Arbitration Week, at the UNICITRO, IGAD, United Nations Economic Commission, and the World Arbitration Update. He is the editor-in-chief of the Journal of Law and Social Studies and a member of the editorial board of the Journal of African Law by the Cambridge University Press. And he is also the chair of the award-winning Arbitration Fund for African Students by the School of Oriental and African Studies at University of London. In recognition of all the above and a lot more that can't be summarized, he was awarded the Kent Law Society's President's Award for Outstanding Contribution to Law in May 2025. So, needless to say, Professor Crispus Nyombi is thoroughly experienced and thoroughly knowledgeable in the field of investment law, treaty arbitration, and the Africa Continental Free Trade Area Agreement in particular. Professor Crispus Nyombi, thank you very much for joining us. He is going to be one of our panelists this afternoon. Our second panelist this afternoon is someone that is fairly well known to me. He is a colleague and someone that I have studied with and I know fairly well from school, Mr. Derek Chizito. Mr. Derek Chizito is, I beg your pardon, I hope the host, I was requesting your help just to make sure that the mute remains muted. Mr. Derek Chizito is an advocate of the High Court of Uganda. He is a member of the Chartered Institute of Arbitrators. He is a graduate from the New York University, where he obtained a master's in international banking, law regulation and arbitration. He will confirm for us. He has advised several clients in complicated disputes across very many sectors, from oil and gas, construction, and under major arbitration regimes such as the International Chamber of Commerce, the London Court of International Arbitration, and International Center for Settlement of Investment Disputes. Currently, Mr. Derek Chizito is in London, where he is working with a boutique arbitration law firm called Three Crowns in their London office, dealing in international arbitration. He is also affiliated to Max Advocates in Kampala, where he is an associate in their dispute resolution and arbitration departments. So Mr. Derek Chizito is also going to be our second panelist today. And again, as I said, both gentlemen are well known to me, and I can guarantee you that the discussion is going to be as enriching as it is knowledge-centered. So having introduced our panelists and having introduced the topic for this webinar, allow me to delve into the introductions, where we're going to hear from our panelists, beginning from Mr. Chizito. They are going to set for us a stage and introduce the agreement, their understanding of it, and where we are as Africa and perhaps where we can go. Mr. Chizito, if you don't mind, could you just introduce the agreement, the Africa Continental Free Trade Area Agreement, to the people on the webinar and give some context? Just shed on us some context on where it comes in, the Free Trade Area Agreement for trade in Africa, what was there before and what we have now. Kindly, you have the floor, sir.
Okay, thank you, Jeffrey. Just to be sure, you can hear me, right?
I can hear you perfectly.
Oh, yeah, thank you. Good afternoon to everyone joining, and thank you, Jeffrey, for the kind introduction. Um, and of course, thanks to the CAB Secretariat for the invitation, and it's definitely a pleasure to be joining Professor Nyombi on this webinar. So, delving into the question, first off, the agreement, it's the agreement establishing the African Continental Free Trade Area. I will not refer to it as the AfCFTA. I feel that's a mouthful. So just allow me to refer it to as the agreement. Um, so the agreement came into force on 30th May 2019. And I would say, as we're having this discussion, it should be up for review because it's supposed to have a periodic review of 5 years. So it's definitely up for review. So it's already been 5 years since the agreement came into force. And the agreement sets up what you've already ably described, and that's the Africa Continental Free Trade Area, which is comprises of 55 countries of the African Union. The idea behind the free trade uh, area is to create free movement of services, goods, and people, basically, and to position Africa on the global market. For those that are joining us, you could compare this to maybe, generally speaking, to the European Union and the way the market works. That's what is behind the agreement. Currently, we have 47 state parties, that is as of January 2024. And by state parties, we mean countries that have ratified and deposited their instruments with the Secretariat, though we have 54 signatories. So 54 countries have signed on to the agreement. Only one of the 55 African states hasn't, and that's Eritrea. I believe works are ongoing to have them sign up and ratify. So you did ask, what did we have before? First off, this convention goes back to about 1990 when we had the Abuja Treaty in 1991 with the idea of establishing a single market for the continent. Again, same goals: ensure free movement of people, eliminate non-tariff barriers, ensure free movement of goods and services across the continent. Back then, the idea was to have this done at a regional level, first off, as we move towards having the whole continent under one single market. So we've heard of the East African Community, we've heard of IGAT, we've heard of SADC, probably heard of, they're about 8 in number, I won't go through all of them, but that's what we've been having, and it's still what we have. So the idea was to have those regional economic communities try to achieve the idea of a single market at a regional level. So in 2012, that's when the discussion and negotiations around the agreement started. And it's part of the 2063 agenda, Africa Agenda, to again have a single market for the continent, have no tariff barriers, and free movement of goods and people. Yeah. So the agreement, again, maybe just to, and this will lay the foundation for the discussion, I believe, when we get to arbitration. The agreement has protocols, and for those joining us probably for the first time and may not be conversant with what are protocols, the best I could describe them is the additional agreements that deal with specific issues. So this particular agreement has a protocol on trade in goods, a protocol on trade in services. From the names, you could tell what particular aspect each of those protocols addresses, and then the dispute settlement mechanisms. Those were negotiated together and came into force at the same time as the agreement. There was a second phase, and under the second phase, protocols that are being negotiated. Some have already come into force, some are still under negotiation, include the protocols on investment, intellectual property, competition, digital trade, and women and youth in trade. So just to set the stage, I believe we'll be looking more into the protocol on investment and its implication, of course, on arbitration. Yeah. So Jeffrey, I think for now that sets the stage. And
yeah, thank you very much. Thank you very much, Derek, for that very apt introduction. So, Professor Crispus, Derek has introduced us to the Continental Free Trade Area. As someone who was involved in this process, what exactly can we learn? What are the implications of the signing of this agreement for Uganda and the broader region, and maybe how far we have gone along that stage where we are now since the signing 7 years down the road? Professor, you have the floor.
Thank you so much, Geoffrey. And first of all, it's a pleasure to be here. I've engaged with CIAB Uganda before, I think with Emilia. So, but also it's very good to see you and Derek and the other organizers on here. Now, it's a very good question. Where are we? And I think before we get where we are, I just wanted to add to what Derek was discussing earlier. Now, when we have to remember that when the AfCFTA agreement was being negotiated, the regional economic communities played the bulk of the work. They are the ones, basically it was devolved to them. So we negotiated it at regional level, at REC level. And those negotiations ended up feeding into the process at the African Union level. But I think one of the key questions we have to ask ourselves, and I think most of those who are here today want to know before we venture any further, if two private parties have a dispute under this initiative, under the AfCFTA, what are the available avenues? I think that's the first thing they want to know. And generally, the AfCFTA dispute settlement mechanism primarily addresses disputes between member states rather than between private parties. So the disputes that are covered are primarily between member states rather than between private parties. And we reference, if you go to Article 20 of the AfCFTA agreement, it establishes a dispute settlement body, what we call the DSB, in other words, that is responsible for handling disputes arising from the interpretation and application of the AfCFTA protocols, which Derek has kindly pointed out. However, this mechanism is designed for state parties, meaning that private entities do not have direct standing to initiate disputes under this framework. So while private parties cannot directly bring disputes under the DSP, they can trigger disputes by lodging complaints with their respective governments. These governments can then act on behalf of the private sector or the private individuals to initiate disputes against those member states if they perceive violation of the AfCFTA provisions. So this process is similar to what we have under the WTO, World Trade Organization system, where private entities must engage their national governments to support the process of resolving disputes. And also there's a consultation and panel process to this. If a dispute arises, the first step is typically a consultation phase aimed at reaching an amicable settlement. If this fails, the matter can then be escalated to the DSP for the establishment of a dispute settlement panel. The panel will review the case and submit a report to the DSP, which will then make a binding decision on the matter. So just to add to that, although the AfCFTA generally does not provide a direct mechanism for private parties, arbitration remains a viable avenue for resolving commercial disputes. Parties can mutually agree to resolve the disputes through arbitration, potentially using established arbitration rules such as CITRAL, the ICC. However, this requires both parties to consent to arbitration. and also to notify the DSP of their decisions. And national law also has a role to play here for disputes that do not fall under the AfCFTA framework. So you might be asking, okay, so there are disputes that don't fall under the AfCFTA framework. Yes. Now, generally, disputes, as I've pointed out, the AfCFTA dispute settlement mechanism is explicitly limited to disputes arising between state parties. This means that private parties or private entities, such as business or individuals, cannot directly initiate disputes. And also disputes which are governed by other regional agreements. So the DSM does not have jurisdiction over disputes that are governed by legal instruments of other regional economic communities, such as the East African Community. So this limitation can create overlapping jurisdictions and potentially conflicts. Basically, this limitation itself can create overlapping jurisdictions and potentially conflicts in dispute resolution processes. And also we have to others which are excluded are non-trade related disputes. The AfCFTA is focused on trade related issues, meaning that disputes not directly related to trade, such as those involving human rights and environment, and of course investment, they are not covered by that. And also, but I think I'll stop that in terms of those that are excluded. So as I was saying, for disputes that do not fall under the AfCFTA framework, private parties may need to rely on national laws governing commercial disputes. This means that the resolution of cross-border commercial disputes between the private parties will often be subject to legal frameworks of the countries involved, which can vary significantly and can also create challenges.
So, Professor, I think there's a question right there, and maybe I can also inform the listeners. If you have a question while Professor or Derek discusses, you can put it in the chat box, and we'll have a question and answer session. So, Professor, just to paint us on there where you are. So, what was the reasoning? If all these issues that you have mentioned, it is state parties who can bring a claim before the dispute settlement board, then why is that how it was framed? Let me say, if they knew that the parties involved in the arbitrations or in the actual trade are individual legal persons, companies, then why did you, because you're involved in the process, why did they consider that it is state parties who can bring claims? Maybe you can just give us an idea of why that is that, as well as why that is the system at World Trade Organization.
Now, it's a very good question. The decision to allow only state parties to bring cases under the AfCFTA is rooted in several key considerations related to the nature of international trade agreements and the structure of the AfCFTA itself. Now, firstly, one of them is state sovereignty and responsibility. The AfCFTA is fundamentally a treaty between, So the AfCFTA is fundamentally a treaty between sovereign states, which means that the obligations and rights established within it are primarily between these states or these parties. The dispute resolution mechanism is designed to address conflicts that arise from the interpretation and application of the agreement between the member states, reflecting the traditional model of international law, where states are the primary actors. The second reason are the political dynamics. Allowing only state parties to initiate disputes helps to manage the political dynamics inherent in international relations. States may act out of political expediency, and the state-to-state dispute mechanism can help ensure that disputes are handled within a diplomatic context rather than through potentially contentious direct actions by private entities. This approach aims to maintain stability and encourage cooperation among member states. A third reason is the absence of direct access. So the AfCFTA framework does not provide a mechanism for private individuals or companies to bring disputes directly to the DSP. Instead, private parties must rely on their respective governments to represent their interests. This limitation is intended to streamline the dispute resolution process and prevent an overload of cases that could arise if individual entities were allowed to initiate claims independently. It also reflects a belief that states are better positioned to negotiate and resolve disputes on behalf of their citizens and businesses. Whether we agree with that or not, but that's what it does. And also, there was also an attempt to model this after existing systems. As I mentioned earlier, the AfCFTA dispute settlement mechanism is modeled after the WTO system, which similarly restricts access to state parties. This design choice was influenced by the desire to create a structured and predictable framework for resolving trade disputes, drawing on established practices from international law. And there was a lot of consultations to see what's going on around the world when we're negotiating this. And also there's the potential for future reforms here. So this is not it. As Derek said, these things every 5 years. So while the current framework limits access to state parties, there are ongoing discussions about the need for reforms that could eventually allow for a more inclusive mechanism, such as investor-state dispute settlement. However, these discussions are complex, no doubt, and involve balancing the interests of the state with those of the private investors, which may take time to resolve and may not be realized. So I hope that
Thank you.
answers your question.
It definitely answers the question, though from where I see it, I think the correct answer was just politics. So Derek, now Professor has introduced us to the agreement. He has told us about the dispute settlement system briefly of the board, which moves it to the establishment of a panel. So just paint us the picture for arbitration specifically. Where does arbitration start? Where does arbitration come in the agreement, and at what point? So just walk us through arbitration and how it's provided for under the article, under the agreement, and the different protocols of it.
Thank you, Jeffrey. Hope I'm clear. And just before I get to question of arbitration under the agreement itself, but also the protocols, just let me just pick up on something Professor said and just add a little bit on that. On the use of resolution of domestic disputes, private disputes, I would call them, especially trade disputes. I think one of the other things, and I'm addressing this in the context, of course, of the webinar's topic, but as an arbitration practitioner, or what you're looking out for is what's going to be the effect of instruments such as the Convention of International Sale of Goods. There's little uptake in Africa, for sure, but we've seen countries, for example, recently Rwanda has did submit its ratification documentations. So if there is an increase in terms of trade, which is the whole idea behind the agreement, then some of those private disputes that are going to arise following, of course, the increase in trade from the agreement may be resolved under some of those frameworks. So as an arbitrator, you're looking out to ensure that if you have such a dispute coming before you as an arbitrator, or you're advising as counsel, you are alive to those legal dynamics, because you don't want to be applying the wrong law just because you have not addressed something. So I just wanted to add that, and then move to, like Professor has mentioned, the dispute resolution mechanism under the agreement is tailored towards state disputes. So even in terms of arbitration, it will be state-to-state arbitration and not an individual and the state. So the agreement provides for arbitration, but as an alternative. That is, both states that are subject to dispute must agree to pursue it. And there is no clear framework as to what rules, so all those things will be subject to the agreement of the states, what arbitral rules to use, in terms of the number of arbitrators they're going to use. I think the important thing is the enforcement. The agreement provides a leeway for the losing party to actually go back to the main, I'll call it the mainstream dispute resolution framework, which is the DSB. If an aggrieved party, so for very many arbitration practitioners, of course, one of your selling points to people when you're selling the mechanism is the finality of the award. Now, under the agreement, that finality is contested because in as far as the losing party has the opportunity to go back and submit a dispute to the DSB for you failing to comply with the agreement, it creates kind of a loop. And probably those are some of the things the people that negotiate the agreement will be looking to iron out. I'll use an example. So there is a similar trade agreement between the US, Canada, and Mexico that replaced the NAFTA. And the dispute resolution mechanism under the agreement is almost a replica of what is in that agreement. One of the differences, though, is the exclusion of arbitration, because it's hard to draw a difference between what a panel constituted by the DSP would be doing that is so different from arbitration. It looks more of a duplication of processes. The resolution by the panel has no name, so to say, and then you have arbitration, which is, in my opinion, going to be the same process, at least when you look at the mechanisms and what can happen there. The only difference you have is maybe control of who you get to sit as arbitrator, because when you go under the DSB, then the panel will be constituted by the secretariat, the chairperson of the DSB. So arbitration, per se, under the agreement is sticky, in my opinion, and maybe Professor could enlighten us on why it's that way. But I'll move just briefly out of that and move to the protocol, which I think, and maybe you would want me to pack that for now. I don't know.
Yes, it's okay. I think the investment protocol and also the one on dispute settlement specifically.
Okay. And I think Professor is unmuted, may have something to.
Yes, Professor, you can proceed.
Yes. Yes, I just had some critical commentary just to add to what we have in place. Now, as Derek has kindly pointed out, the AfCFTA includes a protocol on rules and procedure for the settlement of dispute, which establishes a framework for resolving disputes between the member states. So it is state-centric. However, the protocol's effectiveness is questioned for having several shortcomings. So one of them is limited obligation for arbitration. So while the AfCFTA allows states to choose arbitration as a dispute resolution mechanism, there is no obligation for them to do so. This means that states can opt for other methods, potentially leading to inconsistent application of this agreement. So it's not a must. And secondly, there's also a lack of clear guidelines. The protocol lacks explicit guidelines for mediation and arbitration processes, which can hinder effective engagement in these mechanisms. This ambiguity may deter parties from utilizing arbitrations, as they may not fully understand the processes and procedures that are involved. And thirdly, there's also potential enforcement issues. Although arbitration awards are supposed to be enforced according to the protocol, the actual enforcement mechanism remains unclear. The requirement for mutual agreement on arbitration procedures and the need to notify the DSB of arbitration decisions complicates the enforcement process. If one party refuses to comply, the matter must be referred back to the DSB, which can delay the resolution of them. So, to be honest, there's so much.
I think I have a question. So how does this the system, the way you've described it, the state system, how does it compare with the World Trade Organization and the other international systems? Derek has made reference to the agreement between Canada, US, and Mexico. So what we have, how does it compare with what the rest of the world is doing, and what can we change?
It's a very good question. Now, let's start with the WTO. Now, first of all, the structure and composition is different. So the AfCFTA, the dispute settlement DSM, is governed by a dispute settlement body that consists of representatives from state parties. And this body is responsible for establishing dispute resolution panels and an appellant body. And of course, the DSP operates on a consensus basis, similar to the WTO. But it also includes provisions to prevent a single state from blocking the establishment of panels or appointment to the appellant panel. The WTO system, on the other hand, is often referred to as the crown jewel of this system, featuring a more established structure with a long history of operation. The WTO system also comprises representatives from member states and has a well-defined process for appointing panel members and appellate judges. However, it has faced significant challenges, particularly with the recent paralysis of its appellant body due to a lack of quorum, which has hindered its effectiveness. And also, there's also some legal framework and procedural differences. The AfCFTA one is modeled closely to the WTO, whereas the WTO has a more rigid procedural framework, which has been criticized for being slow and cumbersome. The process involves multiple stages, including consultations, panel adjudication, potential appeals, which can lead to a lengthy resolution. And also the WTO has preference for mutually agreed solutions, but has struggled with enforcement and compliance issues on those, particularly in light of recent challenges to its appellant body and how it functions.
So, Professor, and this question is for both of you. In your assessment, how effective is the dispute resolution system under the agreement right now? And what is missing? You've already identified some of what is missing in terms of its purely state-to-state based. So in your assessment, the current system, how effective is it for the perceived differences and disputes that are going to arise, especially considering that over 60% of the businesses and companies in Uganda are medium to small companies. You have a population of over 50% of Africa below the age of 20. You also have a reality of very low levels of integration, lack of a unified language. You also have infrastructure issues, transportation. So with all those likely points of contention in terms of transportation, communication, infrastructure, is the system in its current state effective? And if not, what do you think we need to do to plug in some of the gaps? I think we can start with you, Professor.
Yes, can I first point, because I love pointing out problems and solutions. So let me first point out some of the problems, then I'll hand over to Derek, then I'll come back with a couple of ways we can go around it. One of them is limited access to private sector. I don't need to go through that again. I've already explained that. The next one is lack of clear mediation guidelines, which I've already explained that we don't have that. And also there's also potential for overlap with existing treaties. So by that, what I mean that the DSP does not adequately address potential conflicts with existing, let's say, bilateral investment treaties and other regional agreements. And this lack of clarity can lead to legal uncertainties, particularly when disputes arise involving states that are parties to multiple agreements with differing dispute resolution mechanisms. And also the other one is implementation and operational challenges. It is still in the early stages of operationalization, with some components, such as the appellant body, still awaiting final approval. So the effectiveness of the DSP will depend on again, it's politics, political will. So the willingness of these governments to work together to achieve it. So I'll go to Derek, then I'll come back with solutions of how we can potentially do this.
Yes, Derek, you have the floor.
Yeah, thank you. Thank you, Professor. So I think I will, in terms of the DSP, I think the professor has set out everything that should be, in my opinion, should be said. So just allow me to look at the protocol a little and maybe look at the gaps there, then move back to looking at the solutions. So again, like I said, for the protocol, we have the protocol on investment, which has now been in force. It's made 2 years since it came in, no, since it was signed. It's yet to come into force, to the best of my knowledge, because when there's, I don't think we've had yet 24 member states that have ratified it. And the other thing, which is a gap again, is that the whole dispute resolution mechanism was deferred for further negotiation as an annex, and it was intended that within a year of signing of the protocol, that annex would be ready. I think about a year ago, there was a draft that was either leaked or circulated. I'm not sure, because it seems not to have been a formal communication. And 2 years later, we've not yet had that annex come up, which I think will address some of the concerns we have, especially as regards investor state arbitration. So things like, how will these awards be enforced? I assume it's something that will be discussed. What dispute resolution, either rules or mechanisms, shall be relied on. For example, very often you have bilateral investment treaties making reference, either allowing investors to refer that dispute either to ICSID or UNICITRO. I mean, it's up to the investor or the state. So probably have guidance on that. And maybe the other thing is, a reading of the protocol, you realize that states it was enacted in a manner that reflects the state's concern about the ICDS system. So I look forward to see whether they intend to borrow, which seems to be a trend now, especially among the European countries, and the kind of trade agreements they enter, the establishment of a permanent investment sort of tribunal or court. And the idea here is to create consistency in the decisions and the like. So all that mechanism is something we're still waiting for, and probably will answer some of the questions we have. But just within the protocol itself, and you speak of the kinds of businesses in Uganda and Africa at large, the protocol, just by way of trying to formalize, the protocol is intended to safeguard investments that are made in other African countries. So I'll use Uganda and South Sudan, and I'll go to something probably people will relate to. There was an issue when, about a couple of years ago, when the civil war broke out, some Ugandan traders or investors for that context lost assets and businesses in South Sudan, and that whole compensation process was handled on a diplomatic level. Some people are probably still claim they've not received compensation for that. So what the protocol intends to do is to give private individuals an avenue as to be able to bring claims against states, in this case probably South Sudan or Uganda, and that's built off, of course, the existing ICDS system. But the protocol in and of itself still carries some gaps and things that will probably impede its enforcement, but that will be a long discussion. So just in terms of the problems, that's what I would mention. I don't think I want to go into the depth of that discussion right now.
Thank you very much, Derek. I just have a question. Maybe any of you can pick it up. So do you think there has been any localization of a dispute resolution system under the Africa Continental Free Trade Area? If you look at it, is there anything African about it, or it was control, paste, and copy and paste from World Trade Organization. Have we? Is there anything that speaks to our Africanness or the trade within the local context? Anyone can answer the question. Yes, Derek.
I'll go first and invite Professor to make his addition. Well, I think there's been an attempt to do that, and credit to whoever came up with the system, because when you look at the ISDS system and the complaints people have had, or the complaint states have had, when you speak of Africanization, you're also looking at, first of all, the people that are determining the disputes. Do they understand the African context? And I think just looking at the DSB and how the panel is constituted, the rota, these are recommendations made by African states. So if, for example, Uganda recommended Jeff and Professor Nyombi as their members to that roster, I think the assumption is that they have an understanding of the African context, that if a dispute came up, whether involving Kenya and Tanzania, they would have an understanding of that dispute in terms of the African context. But also, secondly, when you look at, for example, the investment protocol, there are things that they look to address, things to do with sustainability. Now, it is a debate on whether we actually need it or we are just being compelled to jump onto the bandwagon of quote unquote climate change and everything. But these are things that have been definitely catered for.
Derek,
Also,
climate change is in quotes. Professor Crispus.
yeah, I put it in quotes.
Something to say about that.
And then you have the protocol also covering people. The needs of indigenous communities. This is not something you're going to ordinarily find in the current ISDS system. There is no concept of indigenous people. So you have that catered for, but you also have things like labor rights, work, health and safety workers. These are concerns I think that are African and generally need to be addressed. But of course, it falls short in a couple of other instances.
Well, I totally agree, Eric. And just to add to that, the cultural context also was taken into consideration. So the AfCFTA DSB incorporates elements that resonate with traditional African dispute resolution practices. The protocol rules and procedure, for example, allows for the alternative dispute resolution methods such as mediation and conciliation, which are deeply rooted in African customary international law. So we did actually try to a least extent to Africanize, but of course, not the manner we would have wanted to. But also going back to the point the question you raised earlier, Geoffrey, regarding potential reforms. What sort of change, what sort of reforms do we need to this system? I think I didn't get a chance to put in a few words.
Yes, Professor, you can answer that.
Now, one of them is to enhance access for private investors. The second one is to strengthen the enforcement mechanism. And I think that's something that Derek touched on. So the enforcement mechanism has to be strengthened by developing clear and robust enforcement procedures. That's another way we could enhance this. The other one is clarifying legal provisions. So a comprehensive review and revision of legal texts governing the DSP is necessary because there's some ambiguities. This could involve stakeholder consultations to ensure that the revised provisions are clear, consistent, and reflective of the needs of all the parties involved, especially the private sector. And also they should incorporate EDIA. EDIA should be more ingrained into the system, such as mediation and conciliation. It's there, but of course there's no clarity. We need more clarity on how it should operate. And of course, this approach can help to de-escalate disputes and foster a more cooperative environment among member states. But also capacity building and training should also be considered going forward. There should be investment in capacity building for the DSP and its members, which can help to enhance effectiveness of the process. And of course, training programs should be focused on international trade law, negotiation skills, conflict resolution, which can help to equip those officials with the necessary tools to handle disputes more effectively. So it sounds like semantics, but there is potential there for streamlining and improving the system as it is.
Thank you very much, Professor. Though now something has stood out for me. Professor, you've previously written, I believe, in one of your previous publications, Walter Kluwer's, I believe, for the need for a Pan-African Investment Court. And I was waiting for you to make that proposal among the proposed changes, because there is also need for enforcement or under enforcement. Maybe you can just shed some light on your proposal for an African Investment Court and how far you think it can help us resolve the enforcement issue that you have just raised.
Thank you so much. Now, this Pan-African Investment Court, I remember when I first raised it, I think it was 2016. I was at a conference in Cairo, and I remember it was the Attorney General of Nigeria that said, "Oh, Professor, I disagree with you on this court. There's no way it can work for Africa. It's impossible. Arbitration works perfectly. How are we going to create a court? That will add another layer of problems." Now, the EU then popularized it. So it was actually a European, it's the EU that pushed it forward and gave it the impetus. Today, it is being considered, okay, it is being considered not within the African circles, but especially in Asia. It's picking up in Asia currently. But I think, why haven't I not mentioned it yet? Because it's most suitable for handling. For me, I proposed it in the context of investment disputes. And I was waiting for you to get to the investment protocol, so that I can pull out some of those suggestions of why such a court system could work. It's a hybrid because it has the features of arbitration, but also the features of a court system. The idea was to make it will be much more inclusive, taking into consideration African realities. That's why it was considered in some of my publications as a viable contribution. And I have a book coming out later this year with Brill, where I point it out. It's called Green Transition and the Future of the East African Community Member States Investment Policy. So I mentioned that as one of the advice. So look out for that book.
Yes, Professor. Maybe just before I go to Derek for his solutions or what he proposes. Professor, what role do the regional economic blocs have to play? There is overemphasis or a significant emphasis on Africa as a whole, but the argument is coming in at a time where we have so many existing regional blocs. We have COMESA, ECOWAS, we have SADC, we have IGAD, and even on a level of determination of disputes, we have the OHADA, which is 17 countries in Western Africa. There is a court that is established under OHADA. So is there a problem or a risk of multiplicity? What role do the regional economic blocs and the regional economic communities have to play within the broader context of the agreement and specifically dispute resolution?
Now, it has key functions. The RECs, the regional economy, have key functions in the AfCFTA framework. One of them is facilitating trade integration. So the RECs, as I call them, regional economic communities, like the ESC and SADC, and so on and so forth, have established frameworks to eliminate tariffs and non-tariff barriers, thereby facilitating trade among their member states. So this groundwork is critical to the successful implementation of the AfCFTA, which builds upon the existing agreements to enhance trade across the continent. So these are the building blocks of what the AfCFTA is trying to achieve. I think you are there asking, okay, what about multiplicity? We are having conflicting jurisdiction. But also there's the issue of harmonization of policies. So these regional economic communities play a vital role in harmonizing economic policies and regulations among member states. So this harmonization is essential for creating a seamless trading environment under the AfCFTA, as it helps to align the diverse regulatory frameworks that exist across different regions. But also the role they have to play is by providing a testing ground. That's why we shouldn't get rid of them. They provide a testing ground. The experiences and lessons learned from the implementation of regional agreements such as COMESA, ESC, SADC, serve as a valuable insight for the AfCFTA. So in other words, they can learn from the challenges, the processes, etc., to better implement or better reform their own processes. But also they play an advisory role. So regional economic communities play an advisory role to the AfCFTA. The AfCFTA recognizes the importance of these by including them in its governance structure. So RECs are represented in the committees of senior trade officials, in an advisory capacity, ensuring that their insights and experiences inform the broader continental trade agenda. Sorry, I have to go on and on, but also they also assist in addressing overlapping membership. You must be wondering, how can they assist when they are the ones causing?
That was the exact question that was rolling off my tongue, because the overlapping membership is because of the numerous RECs. So how do they solve a problem which they are, so to speak?
So one of the challenges posed by the coexistence of multiple RECs is the potential for overlapping membership, which can complicate trade agreements and policy implementation. But the AfCFTA aims to navigate these complexities by establishing a hierarchy of agreements, ensure that existing regional integrations are not undermined, but rather it builds on that. So in other words, there's a hierarchy. Essentially, it will mean that the AfCFTA has to take precedence. Yeah.
Yes, thank you very much, Professor. That was very, very detailed. So, Derek, I'm back to you. Professor gave us some weaknesses with the current system. Yeah, he proposed a number of changes, enhance access,
Yes.
promote enforcement, clarity of legal provisions, the need for us to
Brad,
increase
right.
ADR. My co-host kindly help me. Help with ADR. So are there any other weaknesses that you see in the system, and how can we just plug those existing gaps? If there's anything you would like to add on that.
Thank you, Jeff. I mean, I think we've exhaustively concurrently discussed the problems and proposed the solutions. I guess I think importantly is a question of enforcement. Everything can be well put out there, but if I can't enforce, then the process is not serving with my trade. And I think there is a lot in terms of revision that needs to be done when it comes to how the recommendations of the disputes board are implemented and what's the effect of non-implementation. I'll just give an example. It's such a loop that if a country fails to implement a recommendation, the aggrieved party has to go back to the DSP, and then a new panel could be constituted, and then they have to look into whether the other party has complied or not, what extent have they complied or not. And maybe we've been saying it's politics, but we mustn't forget that it's international law. So it's hard to police the states, and it's going to take the political will of the states to enforce some of the recommendations made by the panels and the appellant body. And you can do, of course, if you look at other trade areas, I'll again refer to the Canada, Mexico, US trade area. The recommendations are enforced among the three of them. I mean, you either withdraw your benefits. If for example, we have free movement of people and there is a policy in country X that impedes that free movement of people, then as a retaliation, the other party may as well withdraw that benefit to the citizens of the other party. But it ultimately then that only affects the people. It will probably not affect some of the decision makers. And it becomes a question of political will. But political will is it's hopeful when the system is streamlined and clear. I should know that if country X doesn't follow the recommendation, this is my next course of a remedy. And if that doesn't work, then it's this. Then if ultimately that doesn't work, then I know this is obviously a question of diplomacy now, but and I mean there's also compensation that is provided in.
Derek, you raise a very critical issue, which I just want to I want you to just help me maybe propose solutions or just help us discuss further. The question of individual rights against state rights. That in the actual trading of the agreement, you're going to find individual companies are the ones trading, but then when sanctions are coming, they're against the entire or punishment falls on everybody, or you face the repercussions of the actions of an individual player. Do you have any recommendations that you can suggest to how that we can go around something like that? It's something that you've hinted on, that like there's recourse for parties, but unfortunately, it seems like the recourse goes to the entire state. So if that split of individual rights and community or joint rights, maybe if you can just highlight on that. Professor, I think I'll also come to you after Derek.
Thank you, Jeff. When it comes to individual rights and how you can, your best recourse as either if you're advising entity or if you're representing a party is if it's not an investment that qualifies under the protocol, you're going to have to explore diplomatic channels and get, if you're the affected party, get your government in your host state to actually bring this process or commence this process before the SPN so that you have a recommendation and hopefully whoever you, that will be addressed there. But if it's in the context of a qualifying investment, then you have a remedy under the protocol, which you can't directly bring or commence arbitration. And I'm using arbitration here because speculatively, because we haven't yet seen what, I mean, we could end up with a court if the recommendations are carried. Probably the professor made the recommendations at that point. If we have a court, then of course a different terminology, I would believe. But I'll use arbitration for now. You can't bring the arbitration against the state under the investment protocol to enforce your individual rights. And that's as much as you can do when it comes to individual rights, unfortunately. The other remedy is to go through the diplomatic channels, get your state to try and get the other state to the table.
Thank you, Derek. Professor?
Professor, you're muted?
Professor, you're muted. You haven't unmuted yet.
There you go. Yes. So
Yes,
what's the question, Geoffrey?
Yeah, so the question was building off something Mr. Chizito had raised, that the recourse appears to be more of state recourse, that if you have an issue arising out of the agreement, your solution is mostly a recourse in general rights and not private. So we're just assessing how the remedies that are available for private individuals and what they can do. And Mr. Chizito had proposed that Mr. Chizito made a proposal for involving the government and using diplomatic channels that that can help us. So I was just asking you about that, and then we go into the opportunities.
No, well, I totally agree with Eric. I think leveraging on the relationship with the government could be the way forward for individuals. As I said, it's a state-centric system that we have under the AfCFTA. So private individuals will have to rely more on their governments. There are challenges related to that. I think even the very building blocks of the WTO system, that was one of the issues they had to grapple with, individual rights. So yes, it means that states will have a much more bigger role to play And that's where in most cases, private individuals may have to go.
Thank you, Professor. So I think let's just start from there. Just tell us something small before we get into recommendation on opportunities. Can you just give us a small discussion on ADR generally under the AfCFTA? I know there is something on, I think good offices is the word. There is mention on mediation somewhere in there. The other forms of ADR that are available before we escalate it into the more sorry, okay, I was reading a message, into the more dispute resolution systems that are more enforceable. And then anybody who has a question at this point, please feel free. We've gotten, I think, 2 questions so far. After this question, we're going to enter into our Q&A session. And I have 2 questions so far, which I'm going to start with. So anyone with a question, you can just drop it at this point. Thank you. Yes, Professor.
Can I, before venturing into that, can I also say something about the investment protocol? Because I feel that we've neglected it a bit.
Oh, yes, Derek had spoken about it. Please, Professor, you can
We've
speak
not had
about
a chance
it.
to look into it.
Yes.
Now, one of the key changes or the key reforms that we have under the AfCFTA is the creation of this protocol. So the AfCFTA has introduced the protocol on investment, which was adopted in February 2023, which aims to enhance intra-African investment and establish a framework for dispute resolution. However, the current state of the investment dispute resolution mechanism under this protocol raises important considerations regarding the inclusion of investor-state dispute settlement. So the inclusion of investor-state dispute settlement has created a bit of a buzz in academia, especially. The reason why ISDS has a number of challenges or issues associated with it. One of them is the propensity of state actors, or sorry, not rather state actors, rather private actors, to bring disputes against states. And this has created what we call a chilling effect. By chilling effect, it simply means governments are unable to put into place reforms that are geared towards protecting national interests. So the chilling effect means telling the government, you need to chill, stop putting in measures that could affect our profitability. Now, that is one of the challenges we've had. And most of these cases, most of these disputes, it is always a foreign investor from the UK, from this developing world, taking one of our governments, suing one of our governments. Now, take South Sudan, for example. It received this first case, I think it was 2012. So before it could crawl, it had just been created as a country, and already foreign investors were busy suing the country. So that is one of the challenges we have. Now, someone like me, I remember when I was discussing this investment protocol at the United Nations Economic Commission for Africa, I told them bluntly that investor-state dispute settlement, we need to reconsider it. I've made a proposal previously for the creation of a court system, a Pan-African court system. I think I will need another webinar to discuss what the court and how it works. But that is an opportunity there for us. We've had an opportunity for once, as we gear up for the creation of the AfCFTA, to create a system where all African states are able to buy into the idea. We tried that before. We have the Pan-African Investment Code of 2016. Someone called Makan Mbegu is a professor at Geneva. He called us up. We came up with a code for Africa. The idea was to create a treaty. There was no political will. All the African countries said, we're not going to be bound by something like that. We're not interested. So the AfCFTA opened up a good opportunity for us to create innovative solutions, such as a court system. But again, what did we go for? The traditional ways of doing things. Why? Simply because I remember when I was at one of the UNCITRAL, the United Nations meetings, and I asked the question, who's funding all this? 70% of the budget came from the European Union. So how do you expect the European Union to allow you to be getting rid of something like ISDS? Because they know that their own investors will need that. So again, are we independent? Is there a form of neo-colonialism that is going on that is affecting us or stopping us from creating solutions? Sorry, as you can see, I'm quite elated by all this. So
You're quite passionate.
I'll go back to Derek or yourself.
No, Professor, let me go to Derek just because I've seen a number of messages that have come in. I know a few people on the call are students. I know a few people on the call are just young lawyers and early level advocates. In some respects in life, you can argue that I fall in that category. So, Mr. Chizito, as someone who has experienced arbitration, you have done arbitration internationally. You're currently even doing arbitration with 3 Crowns in London. So what opportunities can you see for arbitration through this agreement in terms of opportunities for the young lawyers, opportunities for the advocates, advisors, consultants, professors? So just what do you see or the future with the signing of the agreement?
Okay, thank you, Jeff. For this one, allow me to be optimistic and say I think there is a lot. Well, it might be slow. The process has been definitely slow. Many of the necessary institutions are not yet in place, and I think that's up to budgetary constraints. If you look at the report from the AfCFTA champion last year, I think that he made, I think only 25% of the required required employees that have been approved are in place as of now. But in terms of opportunities for arbitration, experts and all, I think there's a lot. First off, this time we even have an opportunity for our colleagues that are experts in human rights. And because the protocol, for example, on investment dealt so much on human rights and sustainable development. And therefore, you're going to get a point where you either need an expert to discuss some of this. If disputes ever came up, you certainly need experts to speak to some of those issues. You have the opportunity, and I share some of the concerns with Professor, especially about the protocol. It will be very hard to convince someone to actually do what we call treaty planning and plan it around this agreement. If I was advising the investor, I would definitely not encourage them to do that. When we still have bilateral investment treaties, for example, Uganda and Netherlands, that has a more favorable regime for the investor. But in a place where the investor has no option, can't structure their investment that way, for any arbitration practitioner or someone interested in this space, you're looking at an advisory role on structuring that investment. But I must mention it will be very complex because of the requirements. Things like having a statutory seat with a substantial business in a host country, and then what kind of your investment also having satisfy a similar requirement in the other state where you're investing makes it a little bit hard. But if you have that, obviously sitting as an arbitrator is the other available option, especially for people that have the expertise in this space. And maybe I'll also mention being enlisted on the panel at the DSB, of course, and just to be clear, the DSB, for you to be listed there, you must be an expert at law, international trade, and it also says any matters that may ordinarily arise out of international trade. So experts in that have an opportunity. So as a young arbitration enthusiast, just thinking maybe 10 years, if we have if hopefully some of the bottlenecks are addressed, and there might be an opportunity to actually start doing investor state arbitration in this context, and that's in the context of Africa. because as it stands now, and these are issues that have been raised and over again on why do we have African disputes being, why do we have, usually when it's a commercial dispute, the question is, why is it in London? And of course, when it's in ICSI, they're like, why is it in Washington? And there's a phrase, and on this, of course, they always say you're going to meet a white-headed panel of people, and maybe the narrative is now to change that I'll get into a dispute between Kenya and Jeff as investor, and have a panel that I can relate with fully, and the other lawyers on the other side are equally people that I can relate with in the context. In that context, if it makes sense, just be politically correct. So there are lots of opportunities, but even opportunities for colleagues that are not within the legal space. For example, there's need for experts in terms of quantum determinations. You have, and the issues that arise are always, I mean, bespoke. So I can't list everything, but there's an opportunity for everyone. But you must understand the process and how it works. So if I'm going to call on you as an expert on quantum, I'm looking at what's your expertise in this space. Have you even been an expert, or you're going to wake up one morning and you're posting this all over your social media just because I appointed you, and then you're telling the entire world how you're coming to be an expert in this thing. So yeah, I think the opportunities are there. We just have to be hopeful, and hopefully with the review that's upcoming, some of the bottlenecks are addressed. I mean, we've seen the trade increase. We've seen new certificates issued certifying that probably, I think I saw recently, there are goods being moved from Dar es Salaam to Algeria, Uganda, but we also recently flagged off milk to Algeria. So I think with that kind of activity coming up, there's always dispute that's going to arise somewhere, and you're always going to have an opportunity to step in whatever capacity. But importantly is you must be competent. Yeah, so you just have to grow your competence, and when the opportunity comes, you take it on.
Thank you
Yeah.
very much. Professor, some
Yeah,
question?
as you can see, I'm ready to pitch in. Now, one thing I have to point out: the World Investment Report, UNCTAD World Investment Report, was released yesterday. Please go and read it. It kind of corroborates what Derek has said. That there's been an increase. Of course, the AfCFTA has done a lot in terms of achieving that. But also the other thing that also you need to be aware of: the annex to the AfCFTA investment protocol is still being annexed on dispute resolution, etc. Is still being negotiated. So we don't know whether ISDS, investor state dispute settlement, would feature, but we know, of course, Africans are not going to, knowing them, they'll still follow the status quo. But that's still being negotiated. I am part of that process. But also, you mentioned bilateral investment treaties. Yes, those bilateral investment treaties need to go. We have bilateral investment treaties that are what we call first generational, or the old generation of bilateral investment treaties. They contain the standard protections, fair and equitable treatment, full protection and security. What does full protection and security mean? I don't know. One of my PhD students, the former Attorney General of Zambia, is currently a PhD student of mine. So he's looking at FET and its impact on the mining sector in Zambia. So we had a meeting recently. I told him, you need to tell me what this fair and equitable treatment means.
For those, yes, FET is fair and equitable treatment, yeah. Professor. I don't think everyone.
Maybe I've not explained. So our treaties, our bilateral investment treaties, still contain this vague, archaic, old-fashioned, draconian. I don't know which other words I could use to describe them. They need to go. And a few years ago, I wrote a book. I forgot the name of the book, where I examined the bilateral investment treaties of some East African member states. I went around to look for Uganda's one. They say Uganda, Cuba, bilateral investment treaty. Every ministry I went to, finance doesn't have it. Investment authority doesn't have it. So they even have treaties. They don't even know where they are. Uganda, Nigeria bilateral investment treaty. I went to Uganda, asked the ministries, they don't have it. So I sent someone in Nigeria. It was the former Attorney General of Nigeria. Can you get it for me? Say, Christmas, I can't find it. So if an Attorney General cannot find it, then who can find it? So we even have bilateral investment treaties. We don't even know where they are. And we're not the only one. Pakistan was sued by a company from the Netherlands. And Pakistan asked for the BIT. They didn't know that they even had a BIT with the Netherlands. So they asked the Netherlands, can you please send us a copy of that BIT that we did? It appeared that one of their heads of state, when he went to Pakistan, when he went to the Netherlands, signed one and left it there. So only the Netherlands had a copy. Pakistan didn't know they even had one. So we have bilateral investment treaties that need to go. And Article 49, subsection 1 of the AfCFTA investment protocol requires member states to phase them out within 5 years. So that was a welcome relief. I don't know if they will do it, knowing our Africans, but that is something that that we expected them to do. Now, I think I've gone off point, and I'm worried about that. I think we need to do another one of these webinars. So you mentioned about young
Professor, the head of the education committee is on the call. I'm sure she has heard. Heard.
So you mentioned about opportunities for young lawyers and practitioners from this AfCFTA, especially the protocol. So one of them is legal advisory roles. So young lawyers can engage in providing legal advice to businesses navigating the new investment landscape. And that is one of the things they can do. The other one, probably, I would say regulatory and policy development, they can contribute to that. There is a demand for for legal professionals to participate in drafting and reviewing new investment regulations, because most countries have to harmonize. So there's a demand for that. And also capacity building and training. So with the introduction of the protocol, there will be a need for training programs aimed at educating stakeholders about new investment landscape. Young lawyers can engage in that by developing and delivering training sessions. I don't know if the businesses want that, but I'm sure that's something they can do. But also networking and collaboration. So the AfCFTA creates a platform for increased collaboration among legal professionals across Africa. So the young lawyers can leverage on this by joining professional networks and associations focused on trade and investment law, and also by engaging in cross-border legal practices that facilitate investment flows within the continent. But also research and advocacy. Please do research. Come to me and join me for the PhD or something. Do research, engage in research, upskill yourself. That's another way in which you can make yourself more relevant to what is coming our way through the AfCFTA. There you go, Geoffrey.
Thank you very much, Professor. That was a very, very apt discussion, especially on the bilateral investment treaties in line of the signing of the agreement. So we are now going to take questions. There are already a few questions in the chat box, but let me ask. The first one was asked by, I hope that people who have asked questions don't mind me using their names. Eddie Salongo asked whether asked about the viability of the agreement, Africa Continental Free Trade Area Agreement, setting up a unified investor settlement court like the European Union, or whether they will rely simply on ICSID. I think, Professor, you have answered that, but you can just give her an answer. Which of the two would you think would support investment more? So I think she wants us to balance between the court, the Pan-African Investment Court, and whether ICSID or a foreign dispute system would be more helpful. Professor Oderick?
I think Professor is speaking, but he's on mute.
Professor, we can't hear you.
It's okay, Derek, you can take it. I'm happy to, but Derek, you can also take it.
Okay. I think the question concludes by saying, which of the two would you think would support investment more? So I want to address this on two sides, and of course the answer will be then ambiguous, but I think what the court gives you, and my understanding of the concept and from the reading and seeing the in situ debates and around it, is it gives you certainty in terms of the jurisprudence coming out of the court. And just to understand, most of the current issues with the ISDS system is one tribunal will say X, have almost similar facts in another tribunal, and they'll say why. And each of these has implications. I mean, the other day, I think 2 days ago, South Sudan has again a $1 billion award against it that they need to pay. And that's just one of the many they have to pay, I would believe. So states were a little bit, of course, again, backed by this kind of, they believe people, or just maybe the Nigerian case as well, that had us speak about it for entire year on corruption and the like. That was 11 billion US dollars, all coming out because of some created PowerPoint slides that represented at the tribunal and no investment made. So with the court, you probably get certainty in terms of jurisprudence, and hopefully that, and with that certainty, of course, it allows states come out of the regulatory queue they're having and regulate, knowing that if I did this, at least I'm sure the tribunal or the court will not find otherwise. But that's about the mechanisms. Now, speaking on the side of the investor, I would say they probably favor the exit system. For an investor who will be interested in, obviously, because they feel the court takes away from them the ability to pick an arbitrator of their choice to start with, and the flexibility. But I mean, if you could achieve flexibility with the court as well, that's going to come down to how the rules are structured and the like. The only probably thing you won't be able to achieve is having your own arbitrator. So if I want Jeffrey to sit as my arbitrator, then, but also how many times can you appoint Jeff in a period of 5 years? I mean, if you do that more than 3 times, Jeff must disclose under the guidelines on conflict. So you may not achieve much as well on that end as well. But yeah, if I had to pick
Yes.
something that would work for Africa,
Mr. Chisto, your answer is neither here nor there. It's somewhere in the middle.
Can I?
Yeah, I would go with a court.
Yes, Professor.
Can I chip in? I think it's a very good choice, Derek. I'm happy with your choice, especially since yeah. Okay, but I think for the person that asked the question, I think it's perhaps let me do a comparison for him with the various features, the strengths and weaknesses of each, so that he or she can pick out what they want. Now, for the ISDS, here are the strengths. First of all, it is an established framework. ISDS has a long-standing framework that mainly investors are familiar with, providing a sense of security for foreign investments. Also, there's neutrality. The system is designed to offer a neutral ground for resolving disputes, which can be appealing to foreign investors concerned about potential biases in local courts. But it has weaknesses. One of them is the legitimacy issue. So the system faces significant criticism regarding its legitimacy, particularly in developing countries. And critics argue that it often favors foreign investors at the expense of the host state's regulatory rights, leading to a perceived imbalance in power dynamics. And also another weakness is the high cost and complexity. It shouldn't be because it's arbitration, but of course now it is. ISDS proceedings can be expensive and lengthy, which may deter smaller investors and complicate the investment landscape. And another weakness that you should bear in mind is the limited local engagement. The ISDS framework often excludes local communities and stakeholders from the dispute resolution process, which can lead to tension and dissatisfaction among affected populations. And that is something that the AfCFTA doesn't want. The court system is, on the other hand, which I've been advocating for, it has also strength. It aims to address the legitimacy crisis of ISDS by providing a more balanced and equitable dispute resolution mechanism that considers the interests of both investors and host states. And also it has inclusivity at the heart of it. It is designed to include local communities, which the other one is not, and stakeholders in the dispute resolution process, thereby promoting transparency and accountability. And this inclusivity can enhance trust in the investment environment and encourage more sustainable investment practices. And also, it also creates consistency and predictability. So a permanent court, let's say if we have one in Africa, can offer more consistent rulings compared to the ad hoc nature of international arbitration, which may improve predictability for investors. It also has weaknesses, I have to admit, even though I'm in support of it. So establishing it involves significant logistical and political challenges, including the need for member states to agree on its operational framework and jurisdiction. And also, there's a potential for political influence. There are concerns that a court established by African states could be subject to political pressures. I think it was the case of, was it Philip Campbell versus Zimbabwe in the SADC court, which Mugabe had a major, Mugabe intervened in the process and told them, we're not going to accept you. And the court ended up being closed down, etc. So this is, there is precedent for that. So this could happen. But other than that, I agree with Eric. I think this system can actually do a lot of good for us if we are bold enough to take it on.
Jeff, just maybe just slightly
Yes,
to
Derek,
that.
please.
The other would be enforcement. That's because if you have it, then obviously right now, how do we enforce would be calling them judgments or awards from the court? Those are things that of course you would have to address. I mean, ICSID right now has an enforcement mechanism. I know that if I have an award, I can enforce it in Uganda because Uganda ratified convention. So that would be, I mean, the enforcement mechanism for the court definitely would also have to be addressed. So yeah.
Thank you, Derek, for that question. I have a question here for both of you. White and Kess and Queen Mary University released a report. That report came out, I think, a week or two ago. And from that report, we still see that the uptake of arbitration in Africa is low compared to the other continents, despite having many disputes or an increase in the disputes in Africa. And I think we're now at 100 arbitral institutions on the continent. The big matters and certainly the bigger value matters are still ending up in London, they're still ending up in Washington, they're still ending up in Paris. So what is the cause for this, and what hope do we see with the continental free trade area that might change this state of affairs? Let me start with Professor on this one. Professor, people are still coming to London to bring African disputes. So you're muted. You're muted. So that's the question. Why? Yeah, we have 100 arbitral institutions on the African continent, but even Umeme and the government of Uganda are coming to London. Even Sudan's decision that came out last week was a foreign decision. The decision of Mezzanine versus the Mr. Patrick Bitature, they had to go to London. The decision, so this flooding of London and Paris and Washington, even for local disputes, what can we do? And because won't this affect the Africa Free Trade Area agreement?
It's a very good question, Geoffrey. Now, the uptake of arbitration in Africa, it is notably low. And I think you're right, White and Case and Queen Mary University have highlighted that. And in their survey, they revealed that many African users, let me call them users, still prefer established international arbitration institutions, such as the ICC, the London Court, and so on and so forth. And of course, the other thing also they found that the Lagos Court of Arbitration was the highest ranked African institution. And again, it also fell far behind global players, which indicated a significant reliance on foreign arbitration as an avenue for dispute resolution. So why is this? So what are the challenges facing African arbitration? One of them is reputation and experience. So many African institutions lack the established reputation and track record that international institutions, other international bodies, let me call them, possess. This leads to a preference for arbitrations abroad, where parties feel more secure about the outcomes. But also, there's also legal and institutional framework. Now, that legal and institutional framework we have in Africa also creates concern. We are unclear. There are unclear local laws and the perceived inefficiency of local arbitration processes as conspire to deter users from choosing African institutions. So the lack of a robust legal framework and the absence of a history of pro-arbitration decisions further complicates this, has further created this reluctance to use African institutions. But also there's the cost and accessibility issue. High costs associated with arbitration, coupled with concerns about delays and inefficiencies, make it less appealing for parties to resolve disputes locally. So this situation can lead to a denial of access to justice, particularly for smaller entities. So what can the AfCFTA do about it? Now, there are key provisions in it that allow for that relate to arbitration. So the it includes provisions for arbitration as a means of resolving disputes. However, the effectiveness of this mechanism will depend on the mutual agreement of the parties. So is it going to create an increase? We don't know, because it depends on the mutual agreement or among the parties to resort to arbitration, which may limit its use. And also, we have it is state-centric in the sense that the AfCFTA primarily provides for state-to-state dispute resolution, which may not address the needs of private investors adequately. So the absence of a clear framework for investor-state dispute settlement could hinder the confidence of investors in African arbitration institutions. And also capacity. We have a capacity issue that the AfCFTA would have to try to resolve. So the AfCFTA, for it to succeed, it must promote arbitration. There's a need for capacity building within African institutions, and that will help in achieving the sort of increase that we want. So this includes training arbitrators and legal practitioners to handle disputes effectively under the new framework. So I've gone on and on, sorry. But generally, I think there is hope with the AfCFTA, but not a lot, to be honest. I think
Professor, that's quite a dampener to end on.
Yeah.
So thank you, everybody, for making time. We're going to go back to our panelists for their closing remarks. I would like to thank the Chartered Institute of Arbitrators that has put this entire event together. I would like to thank the administrator, Bridget. She's always involved in the background work. You people never see her, but she's the magician working behind closed doors. Anruth Namara, also who's on the call. She heads the Education and Training Committee at SIAB. Thank you very much. So there are very many SIAB activities that we have planned for those who are interested in arbitration, who are interested in alternative dispute resolution. SIAB has a number of trainings that run throughout the year that you can take advantage of and become a member. You can become a fellow. There is a training for those who are interested in becoming an accelerated member between 3rd and 7th July. There's a training that's going to be taking place to qualify for membership of the Chartered Institute of Arbitrators at the cost of $650. Please reach out to SIAB through social media, LinkedIn, they're everywhere. There's also going to be a training also organized by SIAB for fellowship. That is going to be happening in September, 22nd September, 22nd October, 6th and 7th November, and on 4th December. It will cost just $1,400. There is also going to be a conference on international arbitration organized by SIAB Uganda chapter. We encourage you to join SIAB. We need as many members as possible. As you can see, we are still a chapter operating under the Kenya branch. We need more members. We need to grow our membership so we can become a fully fledged branch on our own. That said, thank you. And I'll give the call to Mr. Derek Chizito for your closing remarks and just a brief closing remark from you, and then we'll go to Professor Crispus.
Thank you, Geoffrey, and of course, thanks everyone for joining us, and to the SEAB Secretariat for the invitation, and definitely to Professor for the discussion. Final remarks. Well, I am optimistic that there will be a positive impact on arbitration. It may take a while, may take some time, but you just have to prepare for the opportunities. So, like Professor said, or the two earlier, just grow the capacity, and maybe just briefly about the issues, why there is little uptake. One thing I think two things that we often run away from when the discussion comes up is rule of law and capacity. I am not, and usually, of course, I've advised clients in terms of long-term projects. I'm not telling a client to bet their money, to bet $2 billion on a country or in a jurisdiction where I'm not sure what will be happening tomorrow. So we really need to look at the rule of law, especially for the big projects. I mean, if the project's going to last 25 years, I want some degree of certainty that in 25 years, the country will exist and will have a functional government. So the rule of law becomes indispensable in that discussion, but also capacity. I don't want to get into an arbitration room where we are proceeding as if we are before Justice Mubiru at the commercial court. It just kills the process, delays the process. You have a process that you should take 6 months taking on 1 year because someone wants to file a notice of motion because they have an objection. So yeah, I mean, we need to grow the capacity, but also importantly, we need to participate actively in the rule of law questions of many of the African jurisdictions. Yeah. With that, thank you, and it's been a pleasure.
Thank you very much, Derek, and also thank you very much for your very realistic answer. Yes, Professor, your closing remarks.
Thank you so much, Geoffrey, for this kind invitation. And I'm so glad to see the participants rather, because I know some of them. I could see some familiar names when I was going through. I hope you've enjoyed the session, and above all, basically in my closing, all I have to say is that the discussions we have had today are pivotal as we navigate the complexities of trade and investment in Africa. And the establishment of a court system, sorry, I have to mention that, under the AfCFTA is not merely a legal necessity, it is a strategic imperative for fostering intra-African trade and attracting foreign investment. So let us continue to advocate for these reforms and work together to create a more integrated and prosperous African economy. So thank you all for engaging with us today and your commitment to this important dialogue. Thank you.
Thank you so much, everybody, for making time. Our discussion was supposed to last 2 hours. We have used 1 hour and 52 minutes. So much for African time. We've overachieved. Thank you so much to SEAB for all the logistical support. Everybody who has been on the call from SEAB, everybody who has made time this afternoon to listen in to us. Thank you very much, and we appreciate. Reach out to SEAB in case you have any questions. There are so many trainings, and perhaps if you want, maybe Professor, you can just drop your email address in the chat for anyone who wants to reach out to you. Derek, you can also maybe leave your email for those who want to contact Professor Crispus personally or Mr. Chizito. You can reach out to them, and also the contacts for SEAB are in the chat for people who are interested in any of the SEAB activities going forward. Thank you very much, everybody, and we appreciate your attendance. We appreciate your time, Kanda, and your very, 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 very honest and attentive, your attention that you gave to us, and we appreciate you spending your Friday afternoon with us. Thank you very much, Derek and Professor Crispus Nyombi, for the time, and I wish you all a very lovely weekend. Thank you very much from me, and have a good weekend all.